today. We've talked about client trust accounts before, but there are some nuances to it that I want to raise with particular emphasis in today's session. There are several categories of payments when we are dealing with clients. First of all, we have what's called a true retainer. The retainer that is charged by you, paid by the client, for your availability. And I use a slightly different terminology. I say for taking you off the shelf, meaning you're not available for any other party. You are available for this particular party as and when they need. But you're not going to bill against that amount. That amount is being paid to you strictly for the purpose of assuring your availability. That's a true retainer. That money, when paid, is earned by you when paid. In other words, it must go into your general account. It cannot go into your client trust account because otherwise it would be commingling with client funds. A second category is what I call traditional retainer. This is money paid to you in advance against which you're going to bill for time and energy and work done for the client. So you bill the client depending on your arrangement with the client. You will withdraw money from the client trust account to pay that bill, or that would be an evergreen account where you'll just keep that money to the side and you expect your client to pay as and when billed. But that initial retainer, so to speak, normally, under most circumstances, at least in my thinking, was always money that went into the client trust account. Another category is for monies that have been paid by you, the lawyer, for costs or expenses, whether they be for filing fees or expert witness fees or the like. Those monies having been paid and billed to the client, when paid by the client, can go into your general account. And by the way, the money for the retainer as well as money for the actually paid expenses, those monies, along with the true retainer monies, can be paid by credit card. The next category is for anticipated expenses. You anticipate that the filing fee is going to be $100. You anticipate that the expert witness is going to charge $3,500, whatever the amounts are. But those are not expenses or fees or costs that have yet been incurred. Those monies that you want to be paid for those purposes, those monies cannot be paid by credit card in California. Now, their thinking is that as long as an intermediary can interfere with the payment of that money, that is, that the client could later object, credit card will withdraw that money, and money will be coming out of the trust account. The reason I disagree with the concept of the intermediary is because that's true no matter when you use a credit card. However, there's a protection that you might use to forestall this thinking. I don't think it changes the opinion of the state bar and the rules of professional conduct, but for your own protection, even for payment of the retainer fee, it would seem to me that you can put into your engagement agreement language that says something to the effect that the client will not object to the payment by the credit card to the credit card company at a later date. Now, there is specific language that the credit card company will honor. So I encourage you to talk to American Express, MasterCard, and Visa, and any other card that you may accept payment with, to make sure that you use the exact language of the credit card company. And I will tell you that each credit card company has its own magic formula, its own language. The client always has the opportunity to object to an amount that the attorney will bill, and the forum That's the only thing you're objecting to or restricting. You're restricting the forum to the state bar. You're restricting the forum to the court system. You're not allowing the credit card company to be the mediator, so to speak, of any such dispute. And so, like arbitration or mediation provisions in contracts, you're doing nothing more, and it is enforceable, in my opinion. Again, take a look at the rules of professional conduct in your particular jurisdiction to make sure that you comply with these rules. The best advice, still, irrespective of the rules, is to take these monies and place them into the client trust account until such time as they are, under all circumstances, your money you've earned and been paid for, and then remove them quickly from the client trust account. Again, thanks for joining us today.